Hi, Misty here. I wanted to talk to you for a couple minutes about the Forced Arbitration Act for sexual assault victims and sexual harassment victims. This new law went into effect on March 3rd of this year, and this is a big win in this era of Me Too movement. Typically in the past, any employer, especially at large companies, in your employment contract, there would be a clause that mandated that any claims of sexual harassment or sexual assault would need to be arbitrated. Additionally, they would typically include a confidentiality clause. What this means is that you would be forced to file your claim in arbitration. That arbitration would be binding, which means that you are stuck with whatever decision that arbitrator made. You cannot appeal that decision, you cannot file in court at a later time, and because of the confidentiality clause, you could never speak about what happened, what your claims or what the outcome of the arbitration was. So this had the effect of chilling survivors from coming forward to make their claims. So this act is a good thing because now the survivor has the power back and they are able to file in court. You can decide if you would still like to arbitrate, but at least you have the option of what you want to do, and it's no longer not left up to you and taken away from you. The other aspect of this act is that it's retroactive. So even if you signed an employment agreement before this law went into effect, it's null and void, which means that that clause can no longer be enforced, and you still get to choose where and when you want to file any claims that you might have. The other good thing about this act is that it applies to not only necessarily employment law. It could apply to ride-sharing apps. So when you take an Uber or Lyft, if you claim that you were the victim of sexual assault or sexual harassment, you can file a claim in court. Typically, a lot of these apps hidden in, when you download the app, you click that little tiny button that you've read all the terms and conditions that nobody does, and buried in there is likely a mandatory arbitration clause. So this has the potential to be much broader than just employment law. But how this affects employers is that if you do have a mandatory arbitration clause, you should be reviewing it to make sure that you are in compliance with this act.